There are additional situations where you may come across an invitation to treat: auctions and tenders. They're similar in many ways, but I think it makes sense to keep them apart. So let's look at them one by one. First of all, let's have a look at auctions. Auctions involve several steps, and so it's very important from a contract law perspective to identify each step and to look at what exactly it is. Is it an offer? Is it an invitation to treat? Is it something else? Auctions, usually the process starts by there being an advertisement. Somehow the buyer finds out that an auction is going to take place. The buyer then goes to the auction. The buyer then participates in the auction. And the buyer makes some bids. Now, what if the buyer makes the highest bid, but the auctioneer does not accept it? So that can lead to some problems. And what we're really asking here is, where is an offer? Is it an offer when the auction house advertises the fact that an auction is taking place? Or is it an offer when the auction house asks people to make bids? Or is it an offer when the person who wants to buy something makes the bid? I think we have to separate two types of auctions because they lead to fundamentally different outcomes. Where you have an auction with reserve, then there is no offer. Auctions with reserve basically means that you bid on something, but you know that there is a reserve price. That means that the buyer has stipulated that if something doesn't reach a certain price, if the bidding doesn't go up to a certain level, they're not going to sell. So when there is reserve, with reserve, then no offers are involved and the buyer has no right to claim that a contract has been formed, because if there's no offer, then of course there can be no acceptance and no contract. The situation is different where we have auctions without reserve. So when an auction is advertised as being without reserve, what that means is that the auction house promises that the highest bidder will get the item that's being auctioned off. Now, by implication, that means that if you are the highest bidder and you have made your bid, then that somehow must be tantamount to acceptance. So what the auction house did in that case must be the offer. So this is exactly the inverse of what happens with auctions that are with reserve, because when they are with reserve, you as the buyer make the offer and the auction house gets to decide whether they're going to accept or not. So where the auction is without reserve, there is some sort of agreement beforehand that whoever makes the highest bid is the person accepting, not the person making the offer, the person accepting. So how do we kind of take this apart legally and look at the individual steps? Now, the way that the court has dealt with this, and we got the case of Warlaw and Harrison, which is a very famous case to do with auctions, is that the courts have come up with this concept of a collateral contract. So in essence, you have two contracts going on. And that, in a way, is a bit of a legal construction that helps us to overcome any problems that we would otherwise have in terms of an offer being accepted or whether a bid can be acceptance. Because as we saw in the example of with reserve auctions, a bid doesn't really amount to acceptance. It can't really do that. So how's that different when you have auctions that are without reserve? Well, first of all, let's look at it from a fairness point of view. If the auction house has said that an auction is without reserve, then clearly the highest bidder should be able to get the items and there should be a contract. So that's simply from a fairness point of view. But how do you then square that with the demands of contract law? So as I said, the courts came up with this two-contract solution. In essence, there is a collateral contract, first of all, between the auction house and the people who come to bid. And that collateral contract is about the promise that the highest bidder will get the item. So it's not really about the particular item. It's not a contract for sale. It's simply a contract of exchange of promises. The auction house promises to sell to the highest bidder, and, well, the bidders promise to show up and bid. So that's the collateral contract. And then, of course, there's the main contract. And the main contract is for the actual sale of the item that's being auctioned off. So by using this concept of a collateral contract, you overcome the difficulties which you would otherwise have in describing the bid made by the participant in the auction as being acceptance. So that is a very smart way of resolving it. And in war law, this was really expressed as an obiter, but in Barry and Heathcote, you will see that this is now clearly established as the state of the law. So where you have an auction without reserve, you take the two-contract approach in resolving the situation and making sure that the highest bidder is in fact contracted to buy the item that has been auctioned off, and that there is a contract and that the auction house can't at that point say no. With tenders, it's fairly similar. It depends with tenders on the type of tender. Some tenders may be invitations to treat, other tenders may be offers. Now, it depends really on the wording. So in some cases, the tender it may be worded in a way that people may come forward and make their bids, but the seller is still able to say, I'm not going to sell, or choose which buyer they want to go with. However, where you have a competitive tender, a secret competitive tender, you do not have that option anymore. So in those types of tenders, where the tender states that the highest bid will receive the tender, the person who put the tender out is no longer able to say no or pick and choose whom they want to contract with, because they've already agreed that they will contract with the highest bidder. And this is exactly what happened in Harvella Investments and Royal Trust Company of Canada. In that case, what really it boiled down to was that there was a tender and two bids were received, and one was a bid for 2-point-something million, and the other one was a lesser amount, but it had a little proviso in it, which said either the lesser amount or 100,000 more than the highest bidder. So that's what's called a referential bid. But a referential bid doesn't correspond to the demands of contract law, in particular of an offer, because it's not clear. You haven't spelled out an exact amount of money that you're putting forward. So in this case, the party that had put out the tender was not able to pick and choose which of the bids it wanted to go ahead with and contract with. They had to go with the highest bid, which happened to be the lower bid in a sense if you cut out the referential bid. So there the party who put out the tender was forced to contract on the basis of the fact that their tender, similar to what we saw with auctions, amounted to an offer. And again, the way you resolve it is by taking the two-contract approach. So there's a collateral contract. The collateral contract is the contract that's sort of by the side, or the contract that induces the main contract. And the collateral contract is basically the promise that the highest bidder will get the contract. And in return, people then go and make those bids. So there's an exchange of promises. I promise you that if you're the highest bidder, you will get the contract. And in exchange, I put in that bid. And of course, by putting in that bid, I will also be bound, if I am the highest bidder, to the contract. So there's an exchange of promises there. But the actual contract is then the contract for sale of whatever the tender was for. And so this two-pronged approach, this two-contract approach, we see that with auctions as well as with tenders. Now lastly, let's look at the issue of termination of offer. That means when does an offer come to an end? Let's assume you've put out an offer, it is a definite offer. How long will you be bound by that offer? How long is the other party able to think about it before they come back and accept it? What are the modes of being able to terminate an offer? And there's different possibilities. Now, the most obvious one is rejection. Anytime that an offer is rejected, it comes to an end. The offer is destroyed. And this is exactly what happened in another famous case, which is Hyde and Wrench. In Hyde and Wrench, Wrench offered to sell his farm to Hyde. And I think the first amount that Wrench wanted to sell it for was £1,200. And then there was another offer made by Wrench. So Wrench offered to sell Hyde his farm for £1,000. At that point, Hyde rejected the offer by making a counter offer, which was for $950. So as soon as you offer something less, as soon as you do not agree with the terms as put forward by the offeror, the offer comes to an end. Now, obviously, the offeror may still go with the lower amount, but in this case, the offeree would have then become the offeror. So in the case of a counter offer, the offeree, the original offeree, becomes the offeror, and the original offeror becomes the offeree. But that's not what happened in Hyde and Wrench, because the counter offer never came to fruition, in the sense that Hyde changed his mind after having made the counter offer and said, "It's all right, I'll pay the $1,000." So in other words, Hyde went back to accepting what Wrench had offered. Wrench had offered to sell to Hyde for $1,000. Hyde accepted. The only problem is that in between the original offer and the acceptance was a counteroffer made by Hyde. Wrench then, when the acceptance came through, said no. So the question faced by the court was, is this allowable? Is this a contract? Where are the offers? Where are the acceptances? Is there an offer? Is there an acceptance? And these sorts of questions. So when we really break it down, it's fairly straightforward. Wrench made an offer for $1,000, for Hyde to buy for $1,000. As soon as Hyde said, "No, but I'll pay $950, at that very moment in time, the original offer for $1,000 had been rejected, and therefore it was destroyed. And that also means that from that point onwards, Wrench was no longer bound to accept the $1,000, even though Hyde then changed his mind and came back with $1,000. So I guess a word of caution for anyone who rejects any offer that's made, namely that once you do that, the offer is destroyed. If you change your mind, the original offeror is no longer bound to go along and contract with you. Now, of course, in many cases, they would contract anyway, and that's fine because they want to have the transaction go ahead. But for other reasons, Wrench decided he no longer wanted to sell to Hyde, and that was okay because his original offer had been rejected and therefore destroyed. Now, we have to distinguish a rejection from a request for more information. And a request for more information is, for instance, when you don't reject the original offer. So let's stick with the simple numbers that we used, that were used in Hyde and Wrench, so 1,000. So let's say someone makes an offer and says, "I'll sell you my farm for 1,000." And instead of saying, like what happened in Hyde and Wrench, where Hyde said, "Oh no, but I'll offer you 950." So instead of saying that, what if Hyde had said, "Can I pay in rates?" Well, that is a question which seeks more information, but it is not a rejection of the 1,000. So you haven't actually said, "I'm not willing to pay that," or "I want to pay less." You just are asking about the modalities of payment. And that's simply a request for more information. And in that case, it's still perfectly possible to accept because the original offer has not yet been terminated. So a mere request for more information does not terminate an offer. And in fact, this is exactly what happened in Stevenson, Jack, and McLean, where there was a request regarding the modes of payment. There was a request for more information, and that did not destroy the original offer. Now, there's also the possibility of withdrawing your offer. If you are the person who made an offer, if you're the offeror, you can always withdraw your offer. Now, the only rule that relates to withdrawing an offer is that you need to let the offeree know, or to be more precise, the offeree needs to find out about the withdrawal. And as we know from Dickinson and Dodds, it doesn't matter how the offeree finds out. So you don't actually have to personally let them know. If they find out some other way, that's good enough. So what matters in terms of the validity of withdrawal of an offer is that the other party, the offeree, finds out about it, that they know about it. In Dickinson and Dodds, they found out from a third party, and the question arose as to whether that is a valid withdrawal given that the offeror himself had not passed the information on because it had been passed on through a third party, and the court said it doesn't matter. It's irrelevant how the offeree finds out. As soon as the offeree finds out, the offer has been effectively withdrawn, and then of course as the offeror you are no longer bound by it. What about offers that are held open? You'll often come across situations where, say, someone is going to sell you their car and you ask for time to think about it, and there's an offer on the table and you haven't accepted yet, and the offeror, the seller, says, well, why don't you tell me tomorrow? Why don't you tell me next week? Gives you sort of a time frame. So the offer is held open for you to come back and make up your mind. So let's say the offeror says, in the case of selling your car, the offeror says, tell me by tomorrow and just give me a call. And the same evening, you get, as the offeree, you get a call from the offeror, says, oh, I've changed my mind, I'm withdrawing my offer. So they've communicated their withdrawal to you. And you say, no, hold on, you gave me until tomorrow to think about it, so you can't withdraw right now. Well, according to the law of contract, you can withdraw. That's because the promise to hold open the offer was not supported by consideration. Now, consideration is obviously something that we haven't done on this course yet, so we'll get to that. But what it basically means is that you cannot have a contract unless things exchange between the parties. So one party makes a promise, namely to hold the offer open, and that party who makes that promise has to get something in return. So the offeree has to give something in return. So essentially what we're talking about is a second contract. So on the one hand, there's the main contract, which in this case would be for the sale of the car. And on the other hand, there is a second contract, or a collateral contract, that induces the main contract. But it's only a contract if it conforms to the rules of contract. And just a promise to keep the offer open is not good enough. If, however, the seller of the car had said, I'll hold the offer open until tomorrow, and you, because you are a smart budding lawyer, would have said, all right, here's $10 just for you in exchange for that promise to keep the offer open until tomorrow. Well, in that case, you would have given something in return, and you would have established a contract, a separate contract. It's not the contract for the sale of the car, it's a contract for the promise that the offer will be held open. So we'll do a lot more on this issue of consideration in another lecture, but for now, let's remember that an offer to hold open the offer is not usually enforceable. Now, what about lapse of time? Now let's turn to lapse of time. What happens when an offeror makes an offer and the offer sits out there and it is not withdrawn, and it just sits there? How long does it sit there? How long can the offeree take to accept it? And the answer is, it depends. It depends on the circumstances. So for instance, in Ramsgate Victoria Hotel in Montefiore, this was a case about the sale of shares, and the offer had sat there for 3 months before it was accepted, and the court held that 3 months is too long. So the offer had in fact lapsed and was no longer capable of being accepted. But it may not always be 3 months. It depends on the subject matter of the contract. So if the subject matter of what's being offered is something that's very sensitive to time, such as in this case the sale of shares, because shares of course go up and down, you'd expect that the offer would lapse after a relatively shorter period of time. But if the offer was for something else that is not so sensitive to the passage of time, such as say the sale of a house or so, you might expect that offer to be able to last for a bit longer. So it really depends. There's no magic rule as to where we draw the line. So you have to really take a reasonable man approach, look at the whole situation, and then determine what's reasonable in terms of the length of time that an offer should be able to sit out there and still be capable of being accepted. But of course, an offeror can always withdraw. So we're talking about situations where there has been no withdrawal. So an offeror has made an offer and then basically nothing happens. So then the question arises, at which point in time does the offer lapse without anyone doing anything? And so 3 months is obviously a long period of time, and it was far too long in respect of what happened in the Ramsgate case. But sometimes, even a week, sometimes even a day may be too long. You just have to look at the facts of the given situation. And then there's also death. So what happens in the case of death? What if the offeror, what if the offeree dies? Well, it really depends on whether an offer was personal. If an offer was personal, then it's not capable of being accepted if the offeree dies. However, if it's not personal, then it may still be capable of being accepted even though the offeree has died. So this is what happened in Carter and Hyde. So Carter offered to sell Hyde a property, and while Hyde was thinking about it, unfortunately Hyde passed away. And then the executors for Hyde accepted basically on the deceased's behalf, and Carter said no because he had offered it to Hyde, but the court held that that was not a personal offer, and therefore the acceptance was valid. So I suppose just as with lapse of time, with death, we have to say that it depends. So let us try and summarize what we've learned about offers. We know that offers must be definite. They must be definite offers. A definite offer is a promise, a definite promise by the offeror to the offeree. And it must be capable of being accepted basically by saying these words: I agree, I accept. But in order to be capable of being accepted by such a simple statement, the offer needs to be clear and hence definite. So a definite offer includes essentially 4 main elements, which we can always test whether they're present, and that will tell us whether or not an offer is in fact there or whether it's something else. These 4 elements are: we need to know who the parties are. We need to know what the subject matter is. We need to know whether there is reciprocation, whether there is something that's given in return. And fourth, we need to know what the time frame is. So when we have all these 4 elements in place, then we can be quite sure that we have a definite offer. Now, if it's something less than a definite offer, it's usually an invitation to treat. An invitation to treat means that someone is inviting someone else to make an offer. So you're not making an offer, you're asking the other side to make an offer. And this happens in the case of advertisements, in shop displays, in auctions, tenders. So we looked at various examples in respect of that. And then we also talked about termination of offers. So once you've made an offer, a definite offer, how does it come to an end? Can you bring it to an end? Well, the easiest and possibly the most common way for an offer to end is by its rejection. So you put out an offer, the other party rejects it. And rejection means basically anything that is short of saying, I agree. So for instance, if you say, I offer to sell you this property for 1,000 and the other party says, no, that's too much, well, then that is a rejection of your offer and the offer comes to an end. We have to distinguish rejection from a request for more information. So if someone merely wants to ask, for instance, about the modes of payment, then that does not terminate the offer. An offer can always be withdrawn, so as the offeror, you always have the possibility to simply withdrawing it, and the only thing that's important is that the withdrawal comes to the attention of the offeree. And then an offer can also lapse because too much time has passed or because of the death of one of the parties. Thank you very much for your attention.